So I had no money. I can't. I can't afford a lawyer, sir. Sir, lawyers are so expensive in your current system, sir. 13.93 lakhs I've already paid, sir. How do, sir, your system is such that it is not for, it's only for the rich people, sir. It's not for poor people.
17 for opposition.
Even for mentioning, for a hearing, I'm charged the full rate of one hearing. So how much can one bear, sir? And see, sir, the issue is again, I'm saying, sir, you might talk about 13.4, 13.2. I'm not a lawyer. I don't know the law.
No, not that way. The thing is,
he is a fighter. He is a fighter. He, in the true sense of the term.
It goes without saying. You think we are hearing you with a closed mind?
No. Very correct. I'm very greatly obliged, sir.
You mentioned the matter 1 year and 20 days. We have upgraded the matter for 1.5 hours. We have been hearing you.
Right, sir. Thank you very much. Appreciate it.
You don't have faith in the court, you report. We throw out your matter right and now.
Sir, if that is, please don't get offended by the choice of words. I'm sorry for that.
Doesn't matter.
Now,
you are right by the letter of arrangement.
My lord, or 13. My lord, I made a mistake. My item is 13.
Item is 13. Yes.
13?
Yes, sir, I'm ready, sir.
Yes, you make your submission. They are not here.
Okay. Sir,
what was the writ petition for?
the writ petition was for abiding by the letter of instruction, letter of restructuring, and which basically said, sir, if you have a copy of the restructuring with you, sir, in front of you,
No.
I'll give it to you.
But Anjan, who was appearing? Where is he? You ask that Smita's clerk is there. Ask him to call one.
So just before we start, sir, last occasion you said to bring the, when there's an alternative remedy available, why don't you utilize that? Right, sir? So here's from the Supreme Court judgment of 16th October. Can I give it to you, sir?
Yes.
Yeah. So as I promised you last time, our case can be finished in 15 minutes.
No, you just give us 5 minutes. We'll go through the order.
Okay, sir.
But I'm appearing on behalf of the appellant. Which I tender apology to this. Lordship, Mr. Om Narayan Rai is addressing before your Lordship. And because of his personal difficulty, he is not able to attend before your Lordship today. And he requests me to make accommodation before.
No, he is appearing party in person. And he has been saying that the matter is pending for over a year.
1 year, 20 days, sir.
Let's say we are ready with the matter. He every time appeared, never default. Today he is in difficulty. Only difficulty is there.
That is why it has been listed as serial number
12. Lordship, I understand your Lordship. I have no quarrel with the respondent, but only difficulty, Mr. Rai is there.
This 2.5 crores which you received from Kerala Police.
2.94, yes, sir.
That was appropriated. It was appropriated to which account? The letter of credit account or to the housing loan or vehicle loan?
No, sir. Sir, there's one cash credit account, cash credit, LC and BG. That was 3.5 crores, total combined. Now, sir, the order was from Kerala Police in the name of our associate company, Cold Bros Violence Institute LLP. The one which had the credit facility with State Bank of India was a proprietorship company. Now, sir, we didn't hide anything from anybody. We said we are utilizing our limits to fund the execution of the order of our associate company. It was no hide and seek. So when the money came from Kerala Police, we ourselves told State Bank, this money is coming on around approximately this date. Please take that money and clear off your outstanding dues. That was it. Now, what has happened, sir? Nutshell, basically a simple thing, sir. Before the pandemic,
All right, Mr. Rai has come.
And I'm sorry, my lord, I was held up, my lord. There was Fathat matter, my lord, item 1, my lord. I was
No problem.
when that money came to us in our account, we told State Bank, take your money and restore our original limits. They did not tell us your account has been restructured. They did not tell us you don't have to pay 1 rupee just now. Now, sir, if you can kindly come to page number 5, you see the terms and conditions that this amount of 162 lakhs was payable, had a moratorium of 12 months from the date of issue of the letter of restructuring, and was payable in 6060 monthly installments, first installment starting in June 2022, 1 year later. Now, sir, when my money came, I was not aware of this. Had I been aware, I would not give them 92 lakhs. Forget about 92 lakhs, I won't give them 92 rupees. I had money in cash in my account. Why should I ask them to take money and restore my LC limit? Because my LC limit becomes 0. So what these people did, I gave them a letter of 19th August, a mail giving them the payback plan. Now he's turning that around and saying, and sir, forget that. I'm saying, let us just forget that for a minute. Just go through my mail of 19th August for 2 minutes, sir, please. Let that be in reply to this, assuming, not admitting. Okay, sir? Can we just take that mail of 19th August?
Yes,
Yes, sir.
page 112.
Correct, sir. Sir, what is my subject matter? Payment and adjustment of the overdrawn dues of your bank. Sir, what is the meaning of overdrawn? Which is due beyond the due date. Right, sir? My payment of 92.56 lakhs to the WCETL account was not even payable on that day. It was not even due. It was due 10 months later. So how can you assume that it's towards payment of the WCTL? Right, sir? Then come to the point for 1, 2, 3, 4. Come to the point, sir. 4. Please adjust rupees 22 lakhs towards OS. OS means outstanding. Balance due to the bank would be rupees 1.42 crores. Okay, sir? Then I say will be received on or around 28th August 1.32. Then I say, please adjust rupees 70 lakhs OS balance due to the bank will be 70 lakhs. At this time, please allow LC of rupees 50 lakhs with 20% margin as usual. As usual. As usual is the operative word, sir, because that was as per the previous sanction letter. Now, sir, my point is very simply this. Had I known about the restructuring letter, I would have also known that my LC limits are cancelled. I would not ask them for LC limit. Forget that, sir. I will have 162 lakhs cash in my account. I don't need a goddamn, sorry. I don't need an LC. I have 162 lakhs cash in my account. Why would I require an LC, sir? What they have done is cancel my LC limits, which is required to procure my materials and do my business. They've taken that, made it 0. The money I got to complete my project, that also part of most of it they've taken away. Oh, sure. Okay.
But by this, he doesn't, there is nothing to indicate that this letter of arrangement was communicated.
The letter of arrangement itself is the restructuring, my lord. Your lordship will see, my lord, the
But then
letter of arrangement.
what is this point? See, on the maintainability issue, we will
No,
definitely
I'm not on the I'll not argue on technicality at all, my lord, since he is appearing in person, my lord. On facts, I shall satisfy your lordship. My lord, his
But
first point
at
is,
the letter of arrangement, his case is very simple. Had the letter of arrangement been made known, on the date when he sent the email dated 19th August 2021, he need not have requested you to approve.
That's very important. Now, my lord, he's my lord, executing a work order of Kerala police. My lord, can he write an affidavit that, my lord, he would have got the, my lord, materials required, my lord, on the basis of cash in his account, or would he get it on the basis of a letter
No,
of
but
credit?
then what he says
Ah,
is,
Lordship will kindly see this, my lord. Kindly allow me to complete, my lord. If he is to procure, my lord, the instruments, he has to do it on the basis of a letter of credit.
no, sir. Cat,
Kindly do not interrupt. Kindly allow me to complete.
Hmm.
Now, my lord, in the restructured letter, my lord, since it is a restructuring, the letter of credit, my lord, which had already devolved. Devolved means, my lord, that he has used it, not paid, my lord, the cash credit had fell down. Therefore, my lord, the letter of credit, my lord, was made zero. Existing limit was there, something was there. My lord, in the restructuring part, it was made zero. He did not have any letter of credit, my lord, to his credit. He could not have utilized, my lord, the letter of credit for the purpose of procuring instruments. My lord, he would not have been able to run the business. Therefore, he needed fresh letter of credit. That is why, my lord, in the mail he writes an issue, fresh letter of issue, also
allow letter of credit.
allow letter of credit. Also, he knows that it is zero. If it is
I don't know.
if it is already a part of, my lord, the sanction, it was already a part of the sanction plan, my lord, let me put it this way. Therefore, my lord, he already has LC. What is the need, my lord, of me allowing him fresh LC? Where is the need of allowing him fresh LC? My lord, he is better than a lawyer
No, no.
today.
What
if-
his contention is, because he was not aware of this letter of arrangement, he thought he was in default.
My lord,
Correct.
And
Correct.
accordingly, he said, please adjust 70 lakhs towards outstanding. Balance due to the bank will be 72 lakhs. At this time, please allow LC of rupees 50 lakhs with 20% margin as usual.
my lord, this is what is showcased. My lord, he is unaware. He is unaware of the letter of restructuring.
But
Let me proceed on this.
doesn't appear to be a chronic defaulters.
My lord, we are bound. My lord, there is a default. My lord, kindly allow me just 1 more minute's time. My lord, he is aware. My lord, he is not aware of the restructuring. I'm proceeding on this basis.
Hmm.
If he is not aware of the restructuring, the letter of credit facility is available to him in terms of the original, my lord, sanction letter. If the letter of credit is already available to him, there is no need for him to write you allow LC of 50.
Because, sir, he is misguiding you. Please allow me to.
Please allow me to complete. Don't interrupt, please. Lord, therefore, my lord, if he is aware, if he is not aware, then in that case, he will not make a prayer for LC because LC is already there. He will make a prayer for LC only if he knows that his LC has become zero. Your lordship will kindly.
My lord, the problem
There is an
is
original
because your application before the debt recovery tribunal has been dismissed.
It's
13-4 notice stands revived.
G1.
There is no challenge to the 13-4. The learned single bench proceeded on the basis that your proceedings before DRT, you can pursue the matter separately. And in this writ petition, you are not questioning the correctness of 13-2 or 13-4. But the fact remains as on date, the 13-4 remains intact. You are a defaulter. How did you get over that? Why did you allow the application to be?
So I had no money. I can't. I can't afford a lawyer, sir. Sir, lawyers are so expensive in your current system, sir. 13.93 lakhs I've already paid, sir. Sir, your system is such that it is not for. It's only for the rich people, sir. It's not for poor people.
17 for opposition.
Even for mentioning for a hearing, I'm charged the full rate of one hearing. So how much can one bear, sir? And see, sir, the issue is again, I'm saying, sir, you might talk about 13-4, 13-2. I'm not a lawyer. I don't know the law.
No, not that way. The thing is, these are all plain, simple facts. They have initiated SARFAESI proceedings. You rightly went before the debt recovery tribunal under section 70, filed an application challenging 13-2 as well as 13-4. In that, there is also a prayer to refund this 92 lakhs. That remedy was the proper remedy. And in the interregnum, suddenly, who advised you, we don't know. You filed this writ petition for an identical relief for getting the 92 lakhs back.
So,
all right, the learned judge considered it, referred to certain decisions, rejected their objection regarding the maintainability. They are on appeal now, canvassing both issues. But the most important fact which we have to consider is this challenge to 13.4 is no longer there. It has become the application is dismissed. So once 13.4 stands revived, where is the question of issuing a direction to refund? You are a defaulter now.
Sir, but the fact of the matter is, had they not taken this 92.5 lakh, I wouldn't have to go to DRT. 13/4, 13/2 wouldn't have arisen. The need for that wouldn't have arisen. So what I'm requesting your lordship, sir, is just please educate whether they took the 92.5 lakhs
That
correctly. or
we'll
not.
adjudicate.
That is the only request I'm asking.
But prima facie, there is document to show that you are aware of the letter of rearrangement.
How, sir? Which document you shows that I'm aware of it?
Statement of account,
Sir,
page 310.
sir, let me explain to you, sir. And I've got an email which please allow me to present.
We can allow you to restore the application under 13.4. We can make because if we render any finding here, it may affect your proceedings because that is the proper remedy.
In fact, my lord, when I had appeared, my lord, I was not there in the writ court, my lord. Before this honorable court, my lord, I had made this prayer. Lord, I said that the best course would be for the parties to go and fight out the battle because it involves.
But
my lord,
can it
disputed
not
question
be settled, sir? He is a running
My lord,
business.
my lord, he is a fighter. My lord, he is a fighter. He, in the true sense of the term, he'll fight tooth and nail. He will not budge. My lord, the banks, my lord, they have to go by the rules, my lord. If it is there, my lord, if he mellows down a bit, my lord, there was a possibility of settlement. Your lord
Sir,
had, my lord, on one.
Sir,
Your lordship
you
had
asked
on one
Mr.
occasion
Shiv
asked-
Mangal Singh, he was there. When you rightly suggested, go there. Straight away that DGM Mr. Sen, where's my money? Give my money, give my money. Arey, sir, you give my money first, I'll give your money. See, my point is, sir, you don't want me, you don't like me. Fine, no problem. Like he read out from somewhere, they wanted us to exit the thing. Arey, you tell me, we don't want you, we don't like you, go. Sir, I had 175 lakhs cash
All
from
right,
my own
you-
money.
You can do.
I could have gone to another account, bank would taken over my account.
Yes, that's what we are.
Yes,
I was
but
about
now
to
it can't be
suggest.
done.
You even now, you can approach another bank to take over this liability and put you on fresh terms
Sir, let me just show you
so
one
that
thing.
the security gets released from them. Same security can be offered.
No, no,
to
no,
a
no.
tripartite.
No, sir, it can't be done. I'll tell you why, sir. I'll tell you why. As per the banking norms, once an account has been restructured, no banker can take over that account for the next 60 months, 5 years. So, but just see this account. Excuse me, please. Can you just give it to him? So, this is the Supreme Court order of 16th October. When you're talking about alternate remedy, you tell us, please. नहीं, tell us, please.
There is an injunction upon him.
No.
Appear. Please don't appear. Cost. Which building is the
Yes, sir.
But this was a case where there was a refusal to consider a prayer for interim relief on the ground of availability of alternate.
Right.
remedies.
So that's exactly what he's suggesting. And see, sir, what has happened in the bargain? We have now been sued by Kerala police to return the 7.36 crores back and pay 12% interest. With 12. Just see this, sir. I'll just show you the last page. We have taken them to the MSME Council. There we hope to get relief. But see, if you say, sorry, no offense meant, sir, but if you say I became aware of the letter of restructuring on the basis of my account credit on 28 June, absolutely right. It was. And I sent, we asked the bank people, they said this is just to stop you from becoming NPA. And I've written it, I've documented it, that mail, I can show it to you, sir. Please allow me to show you that mail.
Please.
Second, sir, but I'll require it by today or by tomorrow. By in this my office, I'll take it out and give it to you. I'm not carrying it with me right now. I'll give it to you. Sir, again, I'm requesting you, please consider this matter with an open mind. This has been done.
Obviously,
Yeah,
it goes without saying,
yeah,
we have been hearing you for 1.5 hours.
correct.
Do you think
I'm-
we are hearing you with a closed mind?
No,
Then
very correct. I'm very greatly obliged, sir.
you mentioned the matter 1 year and 20 days. We have upgraded the matter for 1.5 hours. We have been hearing you.
Right, sir. Thank you very
You-
much.
you,
Appreciate it.
you don't have faith in the system or faith in the court, you report We throw out your matter right and now.
Sir, if that is, please don't get offended by the choice of words. I'm
No,
sorry
no,
for that.
doesn't matter, doesn't
Ah.
matter.
Now,
you are
I
the-
only request, humble request, sir, please don't dismiss the matter. Please reconsider it with an open, in a fresh light after,
Do it.
after I give you that mail which I sent and recorded them, that this,
We will reserve judgment today.
Ah.
You circulate that to the court officer tomorrow.
right,
Hmm?
the mail which I sent,
Whatever it is, with advance copy served on Mr. Ram.
right. Take it, sir.
All right.
All right.
Heard so and so, judgment reserved. The learned,
Guy from, just please show me, sir, please show me. Is a mail from in February 2022.
So it is in response to your mail.
And the 11th November, what he talked, sir, look at him, he's trying to just confuse you. The fact of the matter is that they made us sign the documents and not given the letter when we are sitting in front of them. Why do you
see,
take?
now you're taking a slightly different stand. What was the stand taken by you before the learned writ court where you are
Done it?
represent? The stand taken by you before the writ, in the writ court, where you are represented by an advocate, was that this letter of arrangement was never served on me,
Never?
never served on you.
Right?
That was the stand.
Yes.
But there are documents. That is why rightly you went before the debt regulator. Who advised you to suddenly file one fine morning? The learned judge says that you have not questioned the 13.2, 13.4 in the writ petition. Maybe true in the prayer, it is you don't seek for quashing, knowing fully well that you can't do so. But the prayer A in before the tribunal and the prayer A in the writ petition are identical, where you want this 92 lakhs to be returned to you.
So you yourself just now said the right forum is to go to before the DRT to recover your dues. So naturally my prayer will be the same, no, sir? Ultimately, the objective is the same. See, the violation of the letter of restructuring has been done. That is the point I'm making.
And they cited some bunch of judgments saying that the writ petition is not maintainable.
Yes, my lord, I have those today, my lord.
But
All right, we'll consider tomorrow morning or tomorrow by evening, you
sir,
circulate.
will you please consider this also?
This also tomorrow you make photocopy.
Ah.
You give to, and the other mail also,
Yeah,
which you have.
where the amount they have credit mark. Okay, sir. Sure.
Yes. Next.
Item number 13,